to you if you are handling Singaporeans PIIs or personally identifiable information. So in this webinar, you will know if PDPA is applicable to you. So what are the rights of the data subjects? So what are the details that you need to know? And also we have some offers that you can avail at the end of the webinar on how to be compliant with PDPA. So this will just take for a few minutes and hope you learned something from this webinar. So I am Abel, a Certified Data Protection Officer and currently working at the Digital Defender Cybersecurity IT Solutions. So we have authority and experiences from Philippines, Singapore, USA, and Europe countries. So our company is dealing with cybersecurity and data privacy since 1973. So we are here to help organizations who wants to be compliant with any data privacy law. So is PDPA applicable to you? So PDPA is an act to govern the collection, use, and disclosure of personal data by organizations, and to establish the Do Not Call register and to provide for its administration. So PDPA is an act to govern the collection, use, and disclosure of personal data by organizations. So it is passed last October 15, 2012, and there are some major amendments to the PDPA were proposed and passed in 2020. So among other changes, data protection obligation has added, namely the data breach notification obligation. So PDPA established the Personal Data Protection Commission as a regulatory authority governing data protection in Singapore. So if you are an organization, which means and includes any individual, company, association, or body of a person, corporate or unincorporated respective, and whether it had been formed or organized under the law of the Singapore, or has an office or place of business in Singapore, PDPA shall be applicable to you. So what are personal data under PDPA? So it means that any data relating to an individual, which also include data to which an organization has or is likely to have access, and by which an individual can be identified. So the individual's name, address, phone number, email addresses, photograph, computer IP address, national registration identification cards are some of the many illustrations that what constitute personal data. So what are the rights of the data subjects? First and foremost, an organization is required to develop and implement policies and practices and procedures to establish compliance with PDPA. And they shall communicate to its staff such policies and practices implemented. So an organization may collect, use, or disclose personal data of an individual only for the purpose that a reasonable person would consider appropriate in the circumstances, and only if the individual has been informed about or before collecting such data, and of the purpose to which it will be disclosed, used, or collected. So an organization cannot collect, use, or disclose personal data of an individual without such individual express deemed consent. So unless collection, use, and disclosure of an individual personal data is required or authorized by the law. So first, we have the right to be informed. So before the PICs collect the information from the data subjects, they have the right to be informed to where, what, when they will use the data collected. So information about these policies and practices should be made available in a variety of ways. So for example, in person, you can say it in person, you can say it in writing, by telephone, in publication, or any organization's website. So the information presented should be consistent regardless of the format. As I said, an organization must inform an individual of its purpose for collecting, using, or disclosing personal data. And also, The collected data must not be used for anything other than the initial intended purpose. In notification, individuals must be notified of the purpose before they give their consent to have their personal data collected, used, and disclosed. So next is we have right to object. So under right to object, data subject have the right to say no if they doesn't like their information or their personal details to be included in any campaigns that you have. So what is a valid consent under Singaporean's PDPA? So valid consent under Singaporean's PDPA means to first inform users of your website intended collection. So including the purpose for collection and enabling users to opt out before any processing has begun. If users have been notified and still haven't opt out, you're allowed to deem their inaction as implied consent and begin collection, use, or disclosure of their personal data. So as I said, the consent is needed before personal data is collected, used, or disclosed. So an organization shall inform the individuals wanting to withdraw his or her consent of the likely consequences of such withdrawal and shall upon withdrawal of consent cease and cause its intermediaries and agents to cease collecting, using, and disclosing personal data. So if an individual requests withdrawal of his or her consent, the organization cannot prohibit such withdrawal. So next is we have the right to erasure or blocking. So an individual can withdraw his or her consent given by the collection, use, and disclosure of personal data at any time by giving reasonable notice to the organization for withdrawing his or her consent given or deemed to have been given. So next is we have right to access. So an individual has the right to access personal data. So upon request of an individual, the organization shall, as soon as reasonably possible, provide individuals with personal data that is under its possession or under its control, except extremely prohibited under the Act or any other law. So here are the few tips that you can use so that you can easily access or give the information that the data subject requests. So first is we can keep a record of where personal information can be found. So we can conduct a throughout search for personal information. This includes both physical and electronic searches. So we have to remember that never disclose personal information unless you are certain of the identity of the requester and that person's right of access. So the records also the date you received the request for the information, and you have to ensure your staff members know how to handle an access request. And also the legal standard to be met with withholding information as confidential commercial information is high. So be ready to justify such a claim before refusing access. So next is we have right to correction. So an individual may request an organization to correct an error or omission in the personal data about the individuals that is in the possession and under the control of the organization. So the organization is obliged to allow the individual's access to his or her personal data and allow him or her to correct or rectify their personal data when requested by them. As a data subject, what will I do if I find an error in my personal information? So first is you may request an correction to any factual errors or omission. You may would typically have to provide some evidence to back up your claim. So under the law, an organization must amend the information as requested. And if you successfully demonstrate that it's incomplete or inaccurate. So if you and the organization can agree of changing the information, you have the right to have your concerns recorded. So if the organization has previously shared incorrect information with third parties, forward the amended information to those parties so that they can correct their records. Singapore was one of the first countries to implement data privacy law and not only protects the collection and processing of personal data inside its territory, but also puts enforceable responsibility on organizations defined in the PDPA. So PDPA drafted its in 2012 and in full effect on July 2014. So also serve as a so-called spam law, establishing the Do Not Call Registry or DNC that Singaporeans can use to opt out of unsolidated marketing. Since PDPA does not stipulate a time limit for an organization to reply to requests, an organization shall respond to requests within a reasonable time frame. And if an organization is unable to reply within 30 days, the organization shall inform the individual in writing of the time by which it will respond to the request. So an organization has to put in a place a mechanism to readdress the complaints of individuals that may arise. Every organization is duty-bound to design a person as a data protection officer, so who will be responsible for ensuring the organization's compliance with the Act and shall be responsible to address requests made by individuals regarding collection, use, or disclosure of personal data. So they have to ensure that the data protection officer is well-versed in the company's policies and procedures. A DPO will need a lot of support from the data controllers and processors to make sure that the implementation of all security measures are effective in all areas such as organizational, technical, and physical aspects. So an organization is under an obligation to make public the business contact information of the data protection officer. So as a data subjects, if ever you have requests or if ever you have complaints, you can easily address it to the DPO of the organization. So what is privacy impact assessment? So a privacy impact assessment is a tool that documents how the organization protects the personal information in collects, use, disclosure, stores, and destroys, and critically examine the projects or proposed system or scheme to ensure of its compliance with the data privacy law. So it is the responsibility of every organization to make a reasonable security arrangement to prevent unauthorized access, collection, use, disclosure, copying, modification, disposal, or similar risks of the personal data in its possession or under its control. So doing privacy impact assessment can predict if there is any holes in the processing of your personal identifiable information. So you can see where are the threats and the vulnerability of the procedure. So privacy impact assessment is done once a year if there are no changes with your processing. But if you have new amendments, better do the privacy impact assessment first before changing the processing of the data. So this falls under organizational aspects. So we have to train all staffs. As it said, human error are the most or the major reason of breaches from different companies. So it is important to train your staffs. They should know how the processing of data flows. So they should have a privacy manual to be a guide of any employees, either new or old. We also have to remind our staff on how to maintain the accreditation of the company for being compliant with data privacy law. And if ever there are breaches, we should always be ready and prepared for amendments that we can use to make the processing of the data more secure. So one of the categories under data privacy law is implementing data privacy and security measures. So we have to develop and implement a security policy to protect our personal information. We have to use appropriate security safeguards to provide necessary protection. So this can include physical measures like locking cabinets, or we have to make sure that our cabinets is always locked. We have to restrict access to offices and sometimes alarm system also. We should have also an up-to-date technological tools such as strong passwords, encryptions, firewalls, and security patches. And we should have organizational controls such as security clearances, limiting access. We have to train our staffs and should have agreements if we are transferring the PIIs to another third parties. We have to also review security safeguards regularly to ensure that they are up to date, and that if you have addressed any known vulnerabilities through regular security audits and or pen testings. So make your employees aware of the importance of maintaining the security and the confidentiality of personal information, and hold regular staff training on security safeguards. We have to always keep files that contain sensitive information in a secured area or a secured computer system. So if you are using websites, how can your website be PDPA compliant? So Singapore PDPA requires your website to obtain the consent of users before collecting, using, or disclosing their personal data. So you must notify users about your intended collection and the purpose of collecting, and enable users to opt out. So users need also to be able to revoke their consent at any given time if they choose so. So an organization shall retain personal data only for the purpose for what it was collected, and if required, for legal or business purposes. An organization is required to ensure the accuracy and completeness of the personal data collected by them or on their behalf. So the organization shall not transfer any personal data to a country or territory outside Singapore's unless such transfer is permitted by the Act. Every company should have a breach management plan. So they should know who will act first if there is an attack, what are the next steps or the next procedures, and what they need to do, like containing the cyber attacks, reports, recommendation for preventing these kinds of breaches. Organizations are required to notify the PDPC when a data breach occurs. When the data or the significant scale is like 500 individuals. And in addition, organizations must notify both the PDPC and affected individuals when data breaches resort and likely to result in significant harm to individuals. So Singapore's PDPA applies to any website, company, or organization anywhere in the world that collects, uses, or discloses personal information from inside the territory of Singapore. So if your website has visitors from Singapore, you are required to comply with its consent obligation and other key provisions. So fines for non-compliance can reach up to $1 million. So the general penalty, so it means any person guilty of an offense under this act shall be liable to pay a fine not exceeding to $10,000 or so, or to imprisonment for a term not exceeding 3 years, or with both. The question is, are you ready to face these penalties that can be avoided? If not, call us now as our offer is for limited time only. So this is the end of my webinar. If you have more questions and inquiries, our email addresses are in your screen right now. Always remember, you are your data protected. Again, this is Mabel from the Digital Defenders. Thank you.